Okay, welcome everyone. So we will start the webinar in a few minutes, but I will start off with some housekeeping. So first of all, welcome to the second Big Picture webinar. We will introduce the topic in a few minutes. It will be introduced by Kurt, who is the Work Package 5 lead in the Big Picture project. So this webinar will be recorded and the slides will be made available on the project SharePoint after the meeting. I would like to ask you to stay muted as much as possible, or basically stay muted if you're not speaking. And I would like to invite you to turn your camera on to at least we can see who we have, and it makes it a little bit more interactive. Regarding the questions, feel free to post your questions in the chat, and we will try to monitor them. And we will save time after the webinar for the questions and answers. With that, I will hand over to our chair of today, Kurt.
Yes, thank you so much. First of all, a warm welcome to everybody for our 2 days webinar. My name is Kurt Sattelkarl. I'm pathologist at the Medical University in Graz and leading the Work Package 5, which supports Big Picture on the ethical, legal issues, but also on quality management and standardization. And in this context, we are really glad to have today a webinar on a very important topic that is relevant to many aspects of Big Picture. And before we start with the presentations, I would like to introduce the speaker of today, who will deliver a very interactive presentation of this topic. It's Justus Dumortier. He studied law in Leuven, Nancy, Heidelberg, and information science at ULB in Brussels. Between 1984 and 1992, he was part-time lecturer in information science at the University of Antwerp. In 1987, he became professor in law and ICT at Catholic University Leuven. In 1990, he was the founder of the Interdisciplinary Center for Law and Information Technology and acted as its director until 2014. Between 1987 and 2014, Professor Dumortier is currently a member of the Bar of Brussels as a founding partner of Timelex. Since the start of the law firm in 2007, he has conducted many policy support studies for the European Commission on various issues related to personal data protection and other legal issues related to digital single market. And with his team at Timelex, he is also privileged providing guidance in many European research and innovation actions with a strong focus on the health sector, including Big Picture. Now, Magdalena Kogut, she worked 14 years as a lawyer in the IPT team of Baker and McKenzie in Warsaw. I think you know that's one of the largest international law firms and was recognized by Legal 500 EMEA 2018 and 2019 in the area of TMT as a rising star and next generation lawyer. She provided advice to companies in media technology, pharma, life sciences, fintech, and FMCG industry sectors. Her work included GDPR implementation projects, representing clients before data protection authorities, conducting GDPR compliance trainings, and providing strategic advice in relation to data monetization models. She also advised technology companies in regulatory matters, such as conducting e-commerce digital transformation projects. At Timelex, Magdalena is engaged in providing legal advice in research and development action with focus on AI and health data protection and use. So we are very glad that you, with your expertise, support Big Picture, and we are looking forward to what's new on this very important development, the health data space. So please, the screen is yours. I think yours will start, to my knowledge.
Can I ask Rick to look at the chat?
Sorry. Okay, thank you for this introduction, Kurt. Can everybody see my slides?
Not yet, we see you.
You see me. Okay.
No, Jos, we see your slides.
Yes, they are there.
Yeah.
Not
I think
everybody?
it's a local problem with Kurt.
Okay.
I think it's no problem with your slides, Jos. I can
No,
see it.
it's
Okay,
okay.
I see it now. Yeah.
Yeah,
I
okay.
had to click the slides to see them. First it was just Jos, now it's the slides.
Yeah.
Good. So Marita and I have been involved recently in what they call the impact assessment study for the European Commission for a new regulation, a new European legislation, in fact, about a European health data space, the European health data space regulation. The impact assessment study is one of the steps which the European Commission needs to make before starting the drafting of the legislation. So the impact assessment study is a study on the question what would be the impact if we legislate in this area and let's say translate the given policy options into a legal text, which would be binding for the whole of the Union. In this case, the legislation. Sorry, I have problems with my. Perhaps I should. So in this case, the European Health Data Space initiative is has to be seen in the context of a wider policy of the European Commission. It's called the European Data Strategy. Perhaps you've read in the media or heard about it. The problem that the European Commission wishes to tackle is that most of our data go to and especially consumer data, they go to the United States because there are a series of very dominant companies collecting systematically data of European citizens. And so we lose what the European Commission calls our data sovereignty. We are no longer in control of a large part of the data that we generate as a citizen or as a company or a public administration. And the European Commission wishes to do something about it. And so the European health data space, which is planned, is not an isolated initiative in this sense. There will be similar initiatives in other sectors, like there will probably be an initiative with regard to transport, with regard to energy, perhaps also even agriculture, and other areas where data processing becomes more and more a strategic asset, for which let's say the Union wishes to keep control, and that's the background of it. The next slide. So if we look then at the initiative of the European Health Data Space, the objectives are mainly twofold. On the one hand, the reasoning is that today, when you travel around Europe and you go to a healthcare provider, to a hospital, for example, in another member state, this hospital would probably not have access to your data. So access to health data is limited to, in the best case, to healthcare providers in a member state, sometimes even not. Even your health record will only be accessible to the hospital. For the hospital, you are normally or usually taking care. So the reasoning is that this should change. There is more and more, according to the opinion of the European Commission, patient mobility, and it should the access to the data for taking healthcare should not be limited to one member state. The patient should have access to their own record and also provide access to their healthcare providers wherever they go in the union. So that's what they call primary use of health data. And the second problem and that's what we are going to focus on today in this webinar, the second problem that the initiative wishes to tackle is to provide better access and exchange of health data for scientific research and innovation purposes, also for policy making and regulatory activities, because this also is today very limited. We all know also from our experience in Bigpicture, as we will see later, that it is extremely difficult for researchers who wish to do research on data coming from or stored in different member states to collect them and bring them together. There are all sorts of administrative barriers, interoperability issues, etc., etc. So today, doing research on a European-wide scale on data processed in different member states is extremely difficult, and that's the second problem that this initiative wishes to tackle. Okay, Magda.
Yes, I wanted to add that those of you that are familiar with the data protection rules and GDPR perhaps may recognize these terms, the primary use of data and the secondary use of data. But what came up in our works on the impact assessment was that, in fact, the terms as used in the context of GDPR and these terms as used in the context of European health data space are not necessarily aligned. And that's quite important to our further discussion today. So I just wanted to make note of this, that in the context of European health data, the secondary use of health data covers all scientific use of health data, whereas in the context of GDPR, the term of secondary use of data relates rather to a situation where the data is collected for one purpose and then reused for another purpose. So under GDPR, if there is a research project and the researchers go to patients and asks them to contribute the data specifically for this research project, in the context of GDPR, that would be primary use of data, whereas in the context of the European health space, that would still be the secondary use of health data. So today we will be talking about secondary use of health data in the context of European health space. So all types of scientific use of data, whether or not this data is reused from another purpose.
Okay, so on this slide, I try to show what is currently happening on the level of the union, the policy level, I mean, and where we are today. And so what this slide presents are in fact two parallel circuits. The official circuit is the one on the left. And there you see that the European Commission, normally what the European Commission does when they initiate such an initiative is that it starts with some studies, and then there is a communication to the Parliament and the Council. You know that legislation in Europe is made by 3 institutions together in the normal procedure. That is the Commission, which proposes the text, and then the text should be, to summarize it, adopted by the Parliament and the Council together, which makes it, in this case, a regulation of the Council and the Parliament. And that's the intention here as well. So normally the Commission will do a communication. If it is approved, then the process will start. The Commission will formulate some, let's say, high-level policy options. They organize a public consultation. That's what you see here. This consultation has taken place, and perhaps some of you have participated, because normally these consultations are open for everyone on the website of the Commission, and also you can still today read the results of this public consultation. And once this is finished, then the Commission starts the internal process. And the impact assessment study that I mentioned before is one step. And normally the Commission needs to justify that what will be the impact of the initiative. It will go to what they call the Regulatory Scrutiny Board. They have to submit the initiative to their colleagues in the Commission. It's called the inter-service procedure. And then little by little, when all this is done, they start the drafting process. And in this case, the drafting process will be started soon. Originally, as you can read on the slide, the draft regulation was announced for the last quarter of this year. It will probably be the first quarter of next year. So there is some delay. In parallel, and that's what happens more and more in the health sector, is that the European Commission reserves some funding and asks the member states to organize what they call a joint action. And so, like in this case, the joint action towards a European health data space, the acronym is TEDAS, as you can see here, is in fact a series of meetings between experts or representatives of the health sector, stakeholders of the in the health sector. They organize meetings a little bit like in Bigpicture. They formulate work packages and deliverables, and the output of these proceedings of this joint action is then used by the European Commission as a source of inspiration. It is not binding at all, but it's as we will show you, it can help the European Commission to also to feel a little bit what the opinions are and the experiences are in the member state, and how far they can go with their initiative. One of the interesting deliverables that have been produced by this joint action organized by the member states, and by the way, in which the people in Finland, the stakeholders in Finland, like VTT, the research institute, and Citra, the public authority, have played a determining role, I can say, is this one where I try to identify the main barriers for the data sharing for research purposes. And the main conclusion of TEDAS, the joint action, is that the main barriers are legal. have a legal character, and it's interesting to read because this is to a certain extent also what we experienced in Bigpicture. So if you go to this list of, I don't know if you can read the text, but if you read some of these barriers, then you will see that they identify, for instance, the fact, or they point at the fact that one of the difficulties is that the legislation is different, and the legal landscape is fragmented because of the fact that in the GDPR you have these what they call open provisions, leaving it to the member state to legislate certain details, like the derogations for in case of processing of personal data for scientific purposes. The GDPR doesn't regulate these derogations. For example, in which case you do not have to give access to the data subject, and other possible derogations are not unified in Europe. They are regulated at the member state level, and differently regulated, of course, because in 27 member states, of course, you can imagine that the list of derogations is not the same in every country. So this kind of barriers, I will not detail them all, but you can read that in Europe we also have different interpretations of the notion of what is sufficient anonymization. In some member states, the people will tell you that there is not full anonymization if the data are not completely aggregated. So it's anonymity in the statistical sense. So, for example, if you have statistics on the number of vaccinated citizens in your country, your data will be part of it, but it's completely aggregated. So this is completely anonymous. But as long as you keep the records at the individual level, even if you try to anonymize it to a very large extent, in some member states it will not be accepted. That's also a little bit the opinion in the European Data Protection Board. They will say, as long as the data originate from individuals and you keep them individual, you will always have data that are under the scope of the GDPR, etc. And so there are a number of other, also the concept of pseudonymization is different. There is the question of the legal basis. In some member states, they will give more value to consent of the patient than in other member states, and this is also a difficulty. In some member states, they will require a separate legal basis if you use clinical data for research purposes. In other member states, they will say no. The GDPR tells you that once you have collected the data for clinical purposes, the GDPR says that there is a presumption that you can use them for scientific purposes. These interpretations vary, and these legal discussions, they lead to the fact that there is a large feeling of uncertainty with data providers, hospitals. It's something that you constantly feel. They hesitate to share data because they are not certain whether or not they comply. They still comply with the, and often also it's used as an excuse because they are not particularly fond of sharing their data. So it's also often used as an argument not to be very collaborative in this respect. So that's what we also detected in sorry,
I think we skipped a slide.
Yeah, I skipped a slide, but
so maybe I'll just add from my side that indeed these barriers that have been identified by TEIDAS are very much the barriers that we have identified in the work done in Bigpicture. Well, in Bigpicture, as in many other similar projects, it is prudent and it is necessary to start out with mapping of the legal barriers that will be applicable before the project starts, because usually, as seen from TEIDAS, the legal landscape is so complex. So indeed, knowing that we already started this work to find out what is the legal landscape that will be applicable to the various data submitters in this project, bearing in mind that these submitters are located in different countries. And we focused first on those submitters that will be the first ones to submit the slides. So in particular, we focused on such jurisdictions like Belgium, Finland, Germany, Italy, Netherlands, Sweden, UK. So you can see a spread of different member state countries. So we already were aware that there are differences, and it is a moving target because the landscapes are not only different, as Jos said, because the GDPR allows them to be different, for example, in the area of health data, but because the national, the countries themselves are trying to develop their own data strategies and are starting to develop their own secondary use legislature to allow this data sharing. So to have the most up-to-date knowledge, we developed these questionnaires that were focused on privacy, on IP rights, on open data rules, also on some particular provisions like honest broker, to track what are the requirements from the perspective of the data submitters. And if while the report was already submitted in October, if we were to boil down the findings of this report to one single sentence, and that would be this one, that we have to deal with a different set of rules and requirements for each data provider. Well, this may sound like an exaggeration, but certainly there are different rules depending on the country of the data provider, and sometimes depending on the type of the data provider, whether it is a biobank, whether it's a hospital. So truly the landscape is very much fragmented. And well, probably we don't have time to go through the findings of this report today. I just wanted to relate to a couple of the themes that TEIDAS also identified, and to sort of confirm that indeed we also found those themes to be an obstacle. So as Jos said, for example, the understanding of anonymization and pseudonymization, that certainly varies between the countries. Some countries are more pragmatic in the sense of they consider that the data is sufficiently de-identified or even anonymized if it is not possible to be linked to the individual, but from the perspective of the recipient. So it is not taking such a broad view as, for example, the former Working Party 29 and now European Data Protection Board. Whereas other countries or other respondents have signaled to us that their data protection authorities say that, well, anonymization of data, if we're talking about health image data, that is very difficult because the image itself contains certain characteristics that would allow the provider of this image, so the hospital, to relink this image to the individual. So how can we talk about anonymization of an image if it is still possible to link it? So those struggles indeed have come up in our surveys. Another example are indeed the legal barriers and the complexity of the legislation. So we are not only looking at the GDPR provisions, but the national laws. And I am saying it in plural because often or in all cases, there isn't one national law that the researcher would need to know and examine. There are many laws that theoretically could apply. So the researcher is really in a difficult position. The hospital is in a difficult position because they need to make an effort to interpret these often conflicting laws and sometimes take a risk-based decision that they, for example, decide to contribute to the project while there isn't really a certainty for them that they are doing it in a very safe way, in a completely legally sound way. So this uncertainty and the space for negotiation and discussion has indeed been emphasized in our discussions with the particular jurisdictions. So we decided to focus on one country, so Belgium, and just will briefly talk about how the contributing of slides would be viewed from a perspective of a Belgian provider.
Yeah, so just to give an example, when we worked on the Belgian report, we our conclusion was that digital pathology slides in Belgium would be considered as data. This is not the case in every country. In some countries, they will say, well, the digital pathology slides are associated data and they are part of the biobank. In Belgium, this is not the case. They are the biobank legislation is not applicable. Only the GDPR and the National Data Protection Legislation rules the processing, further processing of digital pathology slides. So that's one thing. As you can read, in Belgium, digital pathology slides at this moment, as far as I could detect, are mainly a matter of academic hospitals. So in university academic hospitals, you will find collections of digital pathology slides, and there the issue is that academic hospitals, and I have had the experience also as a patient. If you go to an academic hospital in Belgium, they will tell you that they will systematically collect your data, and if you undergo a biopsy, that your body material will be reused also for research purposes, because this is part of the university, and the public interest mission of the academic hospitals is not only to provide healthcare, but also to do health research. So it's not at all based on consent. The legal basis is the public interest task of the university hospital, and reusing slides then, digital pathology slides for research projects is in the academic hospital I am a patient from only possible if the hospital itself is involved in the project, because otherwise the reasoning is that the patient would have been misled. They have given their data and body material to the university, and their reasonable assumption is that the data will remain within the scope of the university hospital, used for research, not only for clinical purposes, okay, yeah, but not leave the academic sphere and not be used for completely different purposes. And that's also the reason why, if we discussed with an academic hospital in Belgium about this issue, they immediately tell you, well, it's unthinkable that our digital pathology slides will leave the hospital without control of our ethics committee. Yeah? They will never agree to provide it to an external entity without any form of control. And so the consequence for Bigpicture is obvious. So you could imagine possibilities to overcome these obstacles in the case of Belgium. For example, fully anonymize the data, but we have already mentioned the difficulties to do that. Because then the GDPR and these rules would not be applicable. So that another solution is to wait. And this is something that we did not mention yet, but because of this uncertainty, the European Commission now is planning the European Health Data Space Regulation, but at the same time they are also asking the European Data Protection Board, which is the highest supervisory authority in Europe. In fact, it's where all the national data protection supervisors come together. So this board promised before the end of this year to provide more certainty on the interpretation of the GDPR. Of course, they cannot change the rules. For example, they cannot change the rule that member states can have these different kinds of derogations. It's not something they can do, but at least they could give some guidance about a more unified interpretation of the existing provisions. So that could help to a certain extent. And then another as I said, another difficulty is that when we try to collect these slides from a Belgian hospital, the reaction of the hospital will automatically be, well, how can we control for which research project it will be used? Will it be academic research only, or will it also be accessible for, let's say, non-academic research? Will we have a voice in the opinion of the data access committee, which will be organized or is planned by Bigpicture, etc., etc. And also the main question, and that's also in the background of the whole discussion, is what you very strongly feel if you discuss with an academic hospital in Belgium, and probably it's very similar in other member states, is why should we do it? There is a lack of a driver. Will we get compensated, funded for it? We have to invest resources to make our data interoperable with you, to collect them for you, etc., etc. Will we get some compensation, etc.? And so these are the things that we need to overcome. And this is also, let's say, the main objective that the European Health Data Space Initiatives should pursue. So such an initiative could help. There are some problems, and which are mentioned in this slide. Probably you know that the Commission and the European Union as a whole, they cannot do what they want, because healthcare in Europe, and that it's part of the treaties, is not an exclusive competence of the Union. And you know that in the European Union, it's a very strange construction. the member states have delegated some powers to the union level. It's one of the discussions we have with Poland nowadays for some parts of the treaties. Healthcare is considered as a shared competence. So the union got some competences, but what the member states certainly wishes to keep in their hands is the allocation of resources. So they are always afraid that if the union goes too far in taking some initiatives, it will cost too much for them. And the resources for healthcare are limited. They are not the same in every member state. The maturity level of the health systems is not the same in every member state. Also, the distribution between public sector and the private sector. The public health sector is much more developed in countries like Belgium, France, etc., than it is in Central Europe, in certain countries of Central Europe, etc. So these are additional difficulties that we need to meet. Now, the question then is, what can we expect from the initiative the Commission is working on today? The assumption is that at least there will be some form of coordination at the European level, and I mean at the institutional level. So probably there will be, or even more than probably, there will be some tasks, services, I don't know, which will be given to a new European body or an existing European body. At the moment, the thoughts are going into the direction of the European Medicine Agency and to give them to allocate additional powers and tasks to this agency, but it can also be something else. So the idea would then that decisions on what kind of standards needs to be followed, what kind of security measures need to be implemented, all kinds of other interoperability issues, honest broker services, perhaps also develop a unified method for pseudonymization, things like that could be allocated to a European body. In parallel, the regulation could request the member states to organize and coordinate better the availability and accessibility of their health data for research purposes. So the Commission is thinking in the direction of having some kind of national nodes, or sometimes they call it data authorization bodies or data permit authorities, a little bit following the example, but not necessarily going as far as what exists with FinData in Finland, or more recently with the French National Health Data Hub. So these some coordination where hospitals then would be requested to not necessarily to transfer their data to a national node, but at least give some information on what they have as, for example, digital pathology slides and the accompanying metadata, etc. Coordinate this information and make them accessible in the form of a kind of catalog at the national level. And then in the third place, the regulation probably will contain also, of course, a series of provisions which are directly binding for data holders like hospitals, because, as I said, there is the problem of the trigger, the driver. One possibility is, of course, that at the European Union level, you tell the member states you should force your hospitals to be a little bit more cooperative. This is national interest and union interest. Everybody should contribute. In this case, the hospitals should contribute by providing health data, or at least make their data more accessible and be more transparent in this area. And some ideas which are provided by, for example, the data joint action, which we already mentioned. You can see it here on the screen. Is this architecture of nodes? You can see nodes in the different countries of the European Union. And then you have data consumers like researchers who would not address themselves anymore to the individual hospitals, but could rely on national nodes where they find kind of catalogs. The data providers would be linked to these national nodes. They would be requested to provide a secure processing environment, and would also the nodes would also you see that also data subjects are linked to the nodes. The node should also make health data better accessible for the data subject, for the patients, and perhaps also in certain countries where this is not yet done, be in charge of collecting the consent or the release of the data subject to have their data reusable for scientific purposes, research purposes. It's a little bit the idea in Germany nowadays also. It's called a data donation or release, which patients are being asked to once and for all to give green light to have their health data used for not only for one specific project, but for scientific purposes in general. Some other ideas which and examples of binding rules addressed to data holders will be commented by Magda.
So yes, indeed. So as just said, there are some ideas on the governance framework for the nodes, for the data permit authorities, but there is an idea that the European Health Data Space Regulation should also regulate some also issues regarding the data itself, and then put some obligations on the data holders, so the hospitals. And one of the areas in which this indeed would be, or the Tejeda's thinks that it should be done, is regarding the data quality. The issue of data quality, there is a suggestion that this issue is regulated from a threefold perspective. So first of all, the data providers, the data holders should have a data quality assurance process internally, and this relates only to the secondary use of data. So this part would not apply to the data that regards the medical treatment, but only this data made for the scientific use. And it is proposed that the member states could check if indeed the data quality processes are in place. And that would be, at least that is the idea yet, that this could be enforced by the member states and their authorities. Other aspect is putting an emphasis on transparency of the data. Transparency in the context of the data processing that is done by the hospital prior to making the data available for research purposes. So the data providers would be mandated to be clear about what they do with the data, how they transform the data, how they apply minimalization principle before they make their resources available. But on the other hand, that there should be an obligation for the data holders to be open about what data sets they hold, so about the metadata categories, what qualities the data sets that they have and they could make available, what are the qualities of those data sets. So that is an example of rules that the European data health regulation could impose on the data providers. Similarly, there might be rules on or guidelines on pseudonymization or even the technical security measures. But well, we don't have the time to discuss that, and those were not as elaborate. They were not elaborated yet by the HEDAS. So with our closing slide in summary, how this regulation could impact big picture, Jos, if you could say a few words.
Yes, the question then is what the possible impact could be. Big picture is a long-term project. It's a little bit exceptional, 6 years, and so to a large extent it will be developed in parallel with the. It's interesting. It's two parallel processes. When the project is finished, the big picture project, probably at that time, normally we should have the EHDS regulation adopted, perhaps not yet enforced, but adopted at least. And so the question then is what should happen with big picture in such a new legislative environment, legal environment. One possibility is that the tasks which are performed nowadays and put in place by the big picture project would be part of this European entity, which then would be in charge of the European-wide networks and repositories. The major example people are thinking of are the so-called European research networks, which exist today, but also output of Horizon 2020 and Horizon Europe and Digital Europe actions could also be part of it. Another possible impact also is that the access to slides could be coordinated at a national level. We should a little bit reflect also what the consequence would be for big picture when these national notes will be put in place. And then also when we are discussing at the level of the individual hospitals, the data providers, and how to, let's say, deal with additional providers beyond the current partners of big picture, the question will come up. What will be the let's say the legal obligations, the drivers for hospitals to participate? Will be how far will they be requested to be interoperable, to be to provide access to the data, under which circumstances, etc., etc. So that's the future, which is nowadays not yet clear, not at all clear. We will have to wait for the first quarter of 2022 to get the first idea of what the European Commission will propose in this field. Okay, that's it for us. I don't know if there are some questions from your side. I will stop the presentation here.
Yes, first of all, really thank you so much for your presentation and keeping us informed on this very important process. I think it provides many opportunities, and I think it's still not absolutely clear how the final design will be. So we are really short in time, but I still want to capture the opportunity to take some questions. I see a few hands up, but maybe let me see. Yeah, there is. I think the first was from Joel. Would you like to start with your question?
Sure. It's not clear what will be. I can tell you where we are and what we aim to do. I'm a very good presentation to begin with. Thank you so much. What I can see is that what you talk about in the European health data spaces, it maps very well onto what we are aiming to build in Bigpicture with the natural nodes, or anybody can set up a node and make that interoperable with a network of willing volunteers who want to share data for some reason. I can tell you that this is a good way to do things. I have myself run services according to this scheme for a few years, and we've now sharing data with 24 countries on 5 continents. You mentioned incentives and mapping incentives and having those as drivers for this increased data sharing. That's also a thing we work heavily with, to identify why would people want to do this. We engage with clinics. They obviously want to save costs, prioritize how they spend resources in diagnosing patients. If they can have any support, it's hard to get more pathologists. There's a terrible shortage, very hard to recruit them, so they need decision support, and how can they get that? And then we can connect them to research projects and companies that may deliver stuff to them. But the design we have now, you also spoke of control. The design we have now and the services that we're using to go into Bigpicture, the contributor is the controller, and the contributor has their own DAC and decides everything when it comes to their data. So an incentive could be that they get to be part of large research projects that can have a higher chance to reach success based on data sharing inside that project. And that's the type of interactions we will try to enable also in Bigpicture. In Sweden, there's a difference compared to Belgium, as the digital slides are part of the electronic health records and governed by patient data law. So the caregivers are obliged to provide good care to patients, and this can include data sharing for research. The primary obstacle there is resources. They don't have time to treat patients, so sometimes a little contribution of money so they can take in temporary staff to do stuff like this is a great enabler for research. The data sets I posted there, that's research projects sharing data that they received from healthcare in ethically approved project descriptions approved by on a government level by an agency that they're ethically and legally all right and fulfilling this important public need. Yes, sorry for taking so much time, but good presentation, and I think it's very inspiring to see that where Europe is going with this TEDAS.
Yeah, thanks, Joel, for this additional information. Maybe, okay, Michaela Meyerhofer, a short question.
A very short comment for the sake of time. What is really interesting, and thank you for your presentation, is that you have highlighted the differences between the EHDS and the GDPR, because being involved in some of the experts group there, it seems that the Commission itself is just learning what are the practical difficulties from us researchers. And especially the identification of who could serve which organization, units, nodes as the data providers is critical, or as the national node and agency. And ultimately, the European Commission currently adapts its slides where in the space, or what is the relationship between the European Data Act in contrast to the GDPR, whether it is complementary, overlapping, and so on. And I think there is a lot we can do with, well, following and making with cases such as you presented, the case to policymakers while the legal, why the law is in the making, what the obstacles are. Thank you.
Okay. Yeah, thank you so much. Unfortunately, we are really running out of time, But what I would ask you, I think it's a very important topic. So please provide your comments or questions, also suggestions for further activities along these lines to our project management office. I put the email in the chat, pmo@bigpicture.org, to follow up on this. And again, it's really my pleasure